Thank you. We're here today in 1CA CV16-0755 Armiros versus Rohr. Each side will have 20 minutes to present their argument. Appellant, you'll have you may say when you're pushing of that for rebuttal, but you must keep track of the time yourself. We have the clocks at the podium for that purpose. We are recording the argument both in audio and video. In a couple of days, you'll both be on YouTube. Because we're recording it, please identify your client and yourself when you begin your argument. We've read the briefs, we've conferenced the case, we've had a lot of discussion about this case, so we're familiar with the facts and the argument. So when you begin your argument, please begin with what you think we need to hear and understand. Counsel, you may begin.
May it please the court. My name is Charles Zimmerman, and I am representing the appellant. Your Honors, there is no contract because the parties did not have a meeting of the minds, and because the appellee stated he wanted to take the stone off the market and look at the stone in person, and he had no present intent to bind himself.
Counsel, your client put the stone up for sale on eBay with a buy it now option. Mr. Armiros clicked that button. Isn't that an intent? Pardon me. Isn't that a contract right then and there?
No, it's not, Your Honor, and here's why. Because if you look beyond the push it now, the pushing of the button in Atlanta with the electronic eBay platform, he had no intent to buy it at that time. He had an intent.
But I thought that was by the rules of engagement, so to speak, with eBay. Once you click that buy it now button, you've done that. You have bought what was offered for sale.
Well, but what if you look at what he said and did, what his actions were and his communications were, he said a number of other things besides pushing it now. He said, I just want to take it off the market so others don't.
Did he actually say that?
Yes, he did.
Didn't he also ask Ms. Rohr if that would be acceptable? And didn't he also say that, excuse me, he asked her if that would be an acceptable way to complete the deal, was with him coming here and having someone come with him to verify the value of the item, the integrity of the item, if you will. Didn't he also say, wouldn't that also be considered an oral modification of the terms of eBay's contract? They didn't say, well, we're going to set this thing aside and it's not a buy it now deal. It's still buy it now. It seems to fall under the provisions of the eBay terms, but they modified that. They modified it in one regard. Does that then say that they've tossed out the contract?
No, it says they've modified it such that he put a condition on it, a couple of conditions on it. One, I want to see it and I want to bring another person for a second opinion. Two, if I like it and it's what I want, I have to raise the money.
He didn't really say if I like it. He said if it's what you represent it to be.
Well, I understand, but isn't that a one-way option?
Well, but he's trying to protect himself from being the fraud, and he wants to make sure that what he actually bought is what what was represented on eBay was what was what it was purported to be.
I think you're being generous with that. What he said to his friend or partner was, I want to make sure that it is what I want, but I also want to make sure that other people don't see it. And I have if it isn't what we like, for whatever reason, we're not bound.
Okay, well,
Now, that isn't fair.
Let's talk about Ms. Rohr for a minute. Didn't Ms. Rohr tell the subsequent caller, I believe I've already sold it?
What she said was, first of all, one more thing, and what she said was, I want money down.
No, I'm talking about.
But what she said to the second buyer was, I believe I may have sold it. She put qualifications into that. But what really happened in the subsequent time period was she became very concerned, frightened, probably intimidated by.
Wait, your client was intimidated because someone said, I'd like to meet at a bank or a lawyer's
No,
office?
if you look at what was said, she testified, I'm scared. He's bringing another person. I'm meeting someone on a street.
No.
That's what she
The
said.
communications at the time that she backed out were just, we'd like to meet at a bank or lawyer's office.
Well, the communication.
Stuff that she knew about at the time were bank or lawyer's office. Is that right or wrong?
I'm sorry. Repeat that.
The time that she backed out, the only communications of which she was aware were meet at a bank or lawyer's office. Where are you getting street? Where are you avowing to this court that she was concerned that he wanted to meet?
Because she testified to that, Your Honor.
Based on what?
Her deposition and her testimony at trial.
There was no communication. Was there any communication from his client saying, I want to meet you on a street?
There was, okay, street, a public place is what I meant when I said street. I didn't mean street like a
And you're
corner.
trying to portray this as if he was trying to meet her in some back alley or something.
No, I'm
The
not trying to-
communications were, I'd like to meet you at, you could be at your bank or your lawyer's office.
Well,
Correct?
the communications were, I want to meet you. I'm not putting any money down. I'm bringing another person. Those were the communications. I think a woman with an expensive diamond meeting two strangers call it a bank, but it's a public place. I think discretion, being the better part of her judgment, said this was an unsafe, rather scary situation.
I encourage you to be precise with what you do, with what is being said, because it comes across to one judge over here that you're trying to paint a picture that isn't justified by the record below.
Okay, I can quote the record.
Please.
That never hurts.
Well, I just okay. What she said.
And let me be more precise, because what she said at the deposition, that's certainly part of the record below. But I'm talking about at the time that she backed out, what would have given her a basis to say that they were asking to meet her on the street or something like that, which is what you said?
What he said was, I want to look at the stone. I want to meet you. I want to meet you with another person. And what she was concerned about became the communications that they were having where she said, I'm scared, you're scaring me. Those are all in the record. And she became very concerned.
That was after she had backed out.
I think as she was backing out, that's what caused her to back out, Your Honor. Those are the things that caused her to back out. She wasn't shopping for another price because the best evidence
She'd already sold it to the other.
the best evidence of that, the best evidence of that was he offered more money. He offered more money. He offered $150,000, and she said she couldn't and wouldn't do it because of her concerns.
In fact, didn't she say, no, I've taken it off the market?
She did say that.
Okay, so her response, when you're talking about the integrity of her comments, her comment wasn't that she didn't believe they had a deal, or that they did not have a deal, or that I'm scared for my safety. Her comment was, no, it's no longer for sale. I've taken it off the market. And that turned out to clearly not be true, because she'd already told the second guy that she'd sell it to him.
She said in her testimony, I felt I was going to get a shakedown by two men. That's what she said. That was her feeling. I think we have to ask ourselves why she did what she did. She felt she was getting a shakedown by two people. She said they were threatening to her on the phone calls, the phone calls that took place. She said, I felt afraid. He wanted to bring some person I didn't know. And all of this made her very concerned for her own safety.
So rather, she did all this before she sold it to the second buyer?
All of that was before she sold it, I believe, Your Honors. I think that was all part of what she was feeling, which caused her to go a different direction. It wasn't that she was shopping for a better price, and the best evidence of that, Your Honors, is he offered a better price. He offered the exact same price. And she was, I didn't want to interrupt.
No, go ahead.
But she was concerned that the transaction communication had gotten to the point where she, A, didn't get the down payment that she wanted or the good faith deposit that she requested a number of times. That's clear in the record.
Well, the record's also clear that eBay doesn't require in anything over $10,000 that there be an immediate payment.
No, I didn't say immediate payment. I said down. I said down payment. I said good faith deposit.
Couldn't she have included that in the posting on eBay, saying, buy it now, but you have to put down a X number of deposit?
She said that in the communications at that point.
Couldn't she have done it in the posting on eBay? I'm not talking about the secondary.
Honestly, Your Honors, I don't know the answer to that. I'm not that.
And it's probably not in the record anyways.
And when you click buy it now, there's no provision to immediately, at the moment you're pressing that button, that the money goes. There has to be some time built in for the money to go from the buyer to the seller.
And remember that testimony, Your Honors. That testimony was that Mr. Armiros said, I'm trying to pay it now. I'm trying to get payments to you, but they won't let me do that. Or I'm having trouble with eBay, or I've been on hold with eBay.
But they ultimately got approved, and
No, it never. No, not to my knowledge, Your Honor. He never went through and made those payments.
the payment. I'm sorry. The part of the record that I recall of him telling he's having trouble with eBay is when he was trying to click the buy it now, that they made him jump through some hoops in order to.
No, I think it was, Your Honor, that when he was saying to her, I'm trying to put a down payment on it. I'm trying to make payment, and they won't let me.
Are you saying that he was not capable of making the payment and therefore was incapable of completing the contract?
That's certainly true.
Well,
because he said that. He said I didn't have the money, and he said to his friend, boy, help, we really, if we like it, we need to find the money. We don't have it now.
I thought he testified that he had a line of credit for $150,000, which would have covered that lien.
He said he had a line of credit, but he had not accessed it. And he said to his friend, and the testimony is clear on that, we don't have it, we better find it. I don't know if we can find it, but we'll look at it first. We'll look at it first is the operative language.
He said, I don't know, even though he had a line of credit of $150,000, why would he say to his friend, I don't know how we're going to get the money?
Well, that's a wonderful question. It says to me that maybe he didn't quite have that liquidity he said he had. We know he didn't have it in the savings account. We know he didn't have it in liquid assets. He testified to that. And so he's scrambling with his friend to say, well, we better find it. He never said to his friend, I'll just go to my line of credit and get it.
So does the record show he had a line of credit for $150,000?
Does the record show there was a line of credit?
Yeah.
What was produced was a letter from a banker saying he had a line of credit. But what it didn't say was he had the ability to access it at short notice, or that he had.
What's the difference? I always thought a line of credit meant you could go and access.
Well, because I don't know about your line. I don't know, but I know that
you don't want to get into my finance.
I need to talk about damages, Your Honor, as well.
Let me ask you one quick question before you go to damages, and if we run a little over, it'll be my fault. What's your best case for the proposition that clicking buy it, posting something with a buy it now button, and then having someone click buy it now does not form a contract, either in this jurisdiction or another jurisdiction? Because I think the whole world of e-commerce would be interested to see what we come up with.
Because, and that's the great question. And the answer is because if at that point in time when you're pushing buy it now, and if you don't have the intent to bind yourself, and what you really want is to bind just the other person, and you have conditions upon your buy it now pushing of the button, that doesn't form a contract under any stretch of the imagination.
So if you flip the situation and that diamond was only a $10,000 diamond, even though assuming that she properly described it and everything, but it turns out to be only worth $10,000 as opposed to $300,000 or $100,000, and he had clicked buy it now and she had, would you say that, would your client be arguing that, well, it's not a contract because even though he clicked buy it now, he didn't really intend to bind himself?
Well, you know, that's if she said something like, well, I'm not sure I have the diamond, or I'm not sure I want to sell the diamond, or if I'm just putting out there to buy it now, but I'm not sure if I want to sell it, I just want to see if someone wants to buy it. Yeah, I think that would negate that intent to form a contract or that meeting of the minds. If she's putting conditions on her offer to buy it now, as like the conditions he put on his pushing of the buy it now, I think that would negate that.
But didn't all those conditions come kind of after the buy it now button had been pushed?
Well, what really happened, Your Honor, was, and this was you know, it's kind of argued below, but not really briefed, is they wanted to take the transaction outside of eBay. They wanted to not really do it through the eBay buy it now scenario. They wanted to do other things. He wanted a second opinion. He wanted a second opinion, he needed time to raise the money. And in that scenario where that was all taking place, they were taking the transaction away from the traditional buy it now, ship the goods, pay the money, to a transaction that was now outside of eBay and was between.
If he was really, you know, if he didn't want to agree to those conditions, well, you could say, no, you bought it. You know, I don't want to meet. I've got the diamond.
The honest answer, Your Honor, is that she got scared. She was concerned. There were very threatening things.
But they agreed that night he bought tickets to fly to Phoenix and pick it up.
Well, actually, I'm not sure what that proves. He wasn't
committed to the purchase. He was on his way out here with his friend.
You're assuming he was committed to the purchase. Her point of view was he was committed to get a second opinion, bring another person, not be. So she wasn't really as convinced as you are that was his present intent, to bind himself to buy it, and to deliver the funds. Because that's not what the evidence is, and that's not what they communicated with each other. What he said was to his friend, which was at the exact point in time, we just want to take it off eBay so others don't buy it out from under us, and we'll take a look and see if it's really what we want, and then we will have to scramble to raise the funds.
Why isn't all of that parole evidence? I mean, it seems to me that the contract is the eBay and the button and the posting, and what he's saying to other people is parole evidence as to some type of modification of the contract or something. I mean, we have a contract when that button is pushed. Or tell me why we don't have a contract.
Because they took it. I thought I answered it, but maybe I didn't explain it, because they wanted to take that, buy it now, send the money, send the goods, out of that context and make it something else.
Both parties.
Both parties agreed to do that. Both parties agreed. They wanted to say, wait a sec, it's a big transaction. I want to see it. We have to raise the funds. It's not this buy it now, send it now, ship it now, send the cash. It's something else. And all...
Talk about damages, and we've kind of distracted you. I'm sorry.
Okay. The problem with the damages scenario that was applied in this case is we have been totally speculative about what this diamond was worth. Every case, every appraiser who knows anything about goods and sales, it's what willing buyers will pay a willing seller. It's not what something is listed for. It's not a discount of something is listed for. It's what do goods what are they bought and paid for in the real world? We have two transactions in the real world. We have the original purchase at $166,000 in New York through the diamond deal merchant in New York, totally arm's length. And we have the Bibian sale at $150,000, and we have this $100,000 disputed offer.
Well, and don't we have evidence that that ring was actually sold?
No. There's no evidence it was sold, and that's the thrust of my argument. It was not sold. There is some evidence that that stone may have been listed, may have been the same stone, not evidence that it was ever sold, that it was in fact that stone, but let's assume for the moment it was, that it ever sold at that price. None.
But you did have their expert, your opponent's expert testified.
Mine or theirs?
Your opponent's testified as to a value. And your expert then testified, I haven't been retained to value this ring, but I'm telling you what I found posted on similar things, right? Or
no.
It challenged the value. But don't we have, or what didn't the trial court have, essentially undisputed testimony as to the value? Because your opponent, your expert did not offer a controverting valuation.
Well, what my expert said was, now he's a registered appraiser. You got to remember, their expert
didn't appraise the gem.
I'm just saying what he said as an expert is, you can't evaluate a stone unless you see it, or you have evidence of what it was bought and sold for. And what he said was that one who's certified, who has a legitimate appraiser, not a wholesaler or a retailer, but a certified appraiser in the ordinary course of their professional abilities, cannot appraise a stone by looking at RabNet or looking at eBay transactions or looking at listing prices. He said it has to be what a stone in question or a stone comparable in question actually bought and sold for, not what this stone, which there was no evidence it was this stone, but let's even assume it was this stone, actually was listed for, unless you know what it was sold for. And there was no evidence that stone sold. There's no evidence it sold for that price, but there's no evidence that evidence sold.
Counsel, you've run out of time. I'll instruct Mr. Keefe, because we've asked you a lot of questions, to give you 2 more minutes on rebuttal.
Thank you, Chair.
Thank you. Counsel?
Good morning, Your Honors. Isidore Yetnikoff here, appearing on behalf of...
How do you pronounce your last name again? I'm sorry.
Yetnikoff.
Yetnikoff. Thank you.
Thank you. On behalf of plaintiff and appellee and cross-appellant Evangelos Armiros, if it pleases the court, I think we've gone over the fact that a contract was formed in this case by virtue of the eBay transaction. Both parties had registered eBay accounts, and consented to the rules, terms, and conditions of eBay. And specifically, eBay states that when you click on Buy It Now, a binding contract is formed.
And these two people are both knowledgeable eBay buyers.
Yes, Your Honor. Ms. Rohr testified at her deposition, and based on her own research, she had over 250 transactions on eBay for very expensive luxury items, many diamond rings, luxury items such as Rolex watches, Cartier watches, diamond necklaces, diamond earrings, and assorted gems and expensive handbags. So this is a very experienced person transacting high dollar, high value items on eBay. The rules on eBay are very clear, and you know, they operate successfully millions of times a year. When someone clicks on Buy It Now, the eBay rules say they're obligated to complete the transaction. The buyer is required to pay, and the rules say he's allowed to pay within or must pay within 3 days. Items can be picked up in person, and the buyer can pay in any method requested by the seller. So the argument presented this morning that this was taken outside of eBay is false. The reason I say that is eBay allows for pickup in person. If the court reviews the contemporaneous communications, they were just details on how to arrange to perform the contract that had already been formed. The parties agreed to meet in person. There was no confusion, no disagreement as to how to do so on that Tuesday morning, by the way, which was within the 3-day period that eBay allows. And the parties spoke by telephone, and that's when Ms. Rohr claims she got frightened. But if you look at the communications that followed that telephone call, okay, and that's where Mr. Armiros says, here are the details for my ticket, coming in, on Monday night, I'll meet you Tuesday morning. She says, that's fine. And he also says, I'll bring my friend to have a second pair of eyes, make sure that this is not a scam. And again, she says, that will be fine. So you see that the communications following that phone call, everything is still on track. She says, I'm going to bring all the paperwork. I'll bring the GIA report. I'll bring the authentication documents, so you'll have everything ready to inspect the stone. So things really only go sideways several hours after all those arrangements were finalized. And that's when Mr. Bibian comes in from New York and commits that classic eBay ambush, which is you come in after the deal is done, you avoid all competition, you avoid all bidding, and you email the seller directly and you say, I'll offer you more money. And that's what happened in this case. Mr. Bibian did settle with Mr. Armiros.
What was the theory of his payment? What was the legal theory that apparently prompted him to give $60,000?
I drafted a lawsuit, Your Honor. I'm admitted to practice in the state of New York, and that's where he lives. File in federal district court there. Drafted a lawsuit, sent it to them with one claim: intentional interference with contractual relations. That was the single one claim in my complaint. Sent it to his counsel, and we resolved it quickly thereafter.
So to duck dealing with that issue in court, they paid the $60,000 and you dismissed them out of the action?
Correct, Your Honor.
Thank you.
They were actually dismissed in Arizona. Judge Warner found that the state of Arizona lacked jurisdiction over him by interfering in the contract, but it was a lawsuit to be filed in New York. So the main thing that I wanted to bring out of this is that in the initial communication, and I can quote it for you, the court asked Mr. Zimmerman, the quote is actually, she says, unfortunately, I believe I have the ring sold. Okay, that's her contemporaneous belief at the time.
So her state of mind is it's a done deal.
Yes, Your Honor. And when Mr. Bibian says to her, I'll give you an extra $50,000, cancel the deal with the other guy, it's not like she writes back and says, well, there is no deal. It's not like she denies the existence of a contract to Mr. Bibian. She says your offer is better, and he continues to cajole her to cancel the contract, and she relents. And she goes ahead and emails him canceling the contract. In the first text communication, she says to him, I made a mistake in my listing price. She doesn't say we didn't have a contract. She didn't say, sorry, we can't meet. I've decided to sell someone else. She says, I made a mistake in my listing price. Again, A few minutes later, she texts again saying, I made a severe mistake in my list price. Again, a few minutes after that, for the third time, again, I made a mistake in my list price. The next morning, she files an eBay cancellation request. So she goes to eBay itself and attempts to cancel the transaction. She has to put a reason why she's canceling the transaction. She puts, I made a mistake in my list price. So when Mr. Bibian comes to her now, after the deal is done and offers her $50,000, this is your classic case of seller's remorse.
Did she mention to anybody at any point that she was concerned about meeting with this guy because he seemed weird and she was concerned for her safety?
The record is devoid of that, Your Honor. The first time she ever mentioned that she was afraid was over a year later at her deposition. She had plenty of time to think about her defense, but if you look at the contemporaneous communications and the conduct of the parties at the material times, there was no issue with fear. It was really just seller's remorse. She wanted that extra $50,000. The court also asked Mr. Zimmerman, why, if Mr. Armiros offered to match the $150,000, why didn't she just continue with him? And the reason is because Mr. Bibian wired her a $30,000 down payment. So she was at that point beyond the point of no return because she had already accepted now $30,000 in cash, and she felt like she really had to finish a deal with Mr. Bibian, even though she had a contract with Mr. Armiros.
Can I get you to talk a little bit about damages? Because
yes.
I do think that there's, assuming that there was a contract and a breach, it does seem that the evidence of damages is maybe a little more tenuous than some of the other evidence.
Thank you, Your Honor.
And can you start, and I do not mean to distract from your question.
Please.
What is our review on this? Are we de novo reviewing this, the court's determination of damages? Are we looking at...
damages is erroneous.
Is an abuse of discretion?
Yes.
There's the amount of damages.
I'm sorry?
There's the amount of damages.
Yes, Your Honor. The amount of damages. It's a factual determination made by the court based on the testimony of the two expert witnesses. Now, it's important to note primarily, Mrs. Rohr herself testified she had no idea what the stone was worth. So, she could have listed it for $1, $10, $1,000, $100,000. She really had no idea, and that's the term she used, no idea what it was really worth. So, Appley hired Ron Dome. He, and this is in the record, he consulted with colleagues, did research on RapNet, which is the international exchange. He also examined the GIA report, which is really very close to examining the stone itself, because it contains a detailed report of all the inclusions, et cetera, et cetera. So he found that the stone was worth $389,000, which is what Mr. Bibian had listed it for on RapNet. By the way, both experts agree it was one and the same. The stone that was sold to Mr. Bibian is the same one that Mr. Bibian listed for $389,000. So our expert determined that the ring price from Mrs. Rohr was grossly undervalued, and that's also what the trial court found. Mr. Lynch never rendered a professional opinion on the value of this stone, and that's, Judge Morris, that's what you mentioned. The evidence is uncontroverted as far as damages. If you evaluate what the experts are saying, and I asked Mr. Lynch at trial why he did not testify as to the value, and he said I wasn't asked to do so. In fact,
did he say he couldn't without evaluating the ring?
He never testified. No, Your Honor. No, he did not say that. And I'll challenge Mr. Zimmerman to find in the record. He'll maybe argue that he did, but he did not, Your Honor. Mr. Lynch testified he did not attempt to identify or locate even comparable 8-carat diamonds, which is what we're talking about this case. His report, if you look at the record, his report compares 2-carat diamonds, which are a dime a dozen. Those are very easy, very common.
Don't tell my wife that.
So to speak. Right, mine either. But he'd never produced any report comparing 8-carat stones. Why? And I asked him about that, and he says I was never asked to do so. So he never produced any evidence to refute our expert's valuation at $389,000. So if you have an expert that's coming to court, he's not comparing apples to apples. He refuses to testify as to what the value was. Our evidence is essentially not refuted. Here's the key. The trial court, Judge Warner, still gave their expert the benefit of the doubt. The greatest amount of deviation that Mr. Lynch testified to The greatest amount of deviation was 25%. So Judge Warner gave him the benefit of the doubt and said, okay, $389,000, if there's a deviation from that list price, but up to the maximum 25%, I'll deduct 25%. That's what the court did. So the trial court deducted that 25% and came up with a value of not 389, but it's 389, but 75% of 389, which is 295,250. The court then deducted 100,000 purchase price plus 60,000 that was paid in settlement with Mr. Bibian. And I left a balance of $135,250. That's exactly what this court in Division 2 did in the Keenan case, and we cite it and we discuss it at length. Again, it follows the UCC, which is bargain of benefit damages, difference between the contract price and fair market value at the time of the breach. And so that's what the court awarded us. I go into, very detailed discussion about how the Keenan case applies. And I'd like to talk a little bit about our cross-appeal. If the court has any questions on what I've said so far, I'd be happy to answer that right now.
Well, counsel, on the cross-appeal, Ms. Rohr's husband was dismissed, and after the denial of the motion for new trial, Ms. Rohr appealed. So at that point, Mr. Rohr is no longer in the case, and I understand that a cross-appeal pertains to an appellant. It doesn't pertain to other people who aren't appellants, and I understand that Mr. Rohr is not an appellant in this matter. So how is your cross-appeal proper?
Well, Your Honor, he was a party to the case from day one, and
but the point is once he's dismissed.
Well, he was dismissed in the final judgment. We appealed that final judgment.
But you didn't. You cross-appealed from the final judgment.
Yes, and the only person who's an appellant now is Ms. Rohr. So how can you cross-appeal a non-appellant at this point?
I see what you're saying, Your Honor.
I mean,
we believe that we appealed the judgment dismissing. It was the same judgment, finding breach of contract on summary or reinforcing that, finding a breach of contract, awarding damages, and dismissing Mr. Rohr. It was all contained in the same judgment. So we're not cross-appealing anything to do with breach of contract or damages.
File a timely notice of appeal of the judgment on your own?
I believe we did, Your Honor. I believe we did. Yes. We filed one notice of cross-appeal, Your Honor. That's my answer.
It was a notice of cross-appeal.
Yes, it was.
You didn't file a direct appeal of the... And
I see.
This is a very technical issue, but so is sometimes formation of contract on a buy it now button. And it, the rules are such that we are. So give us your best argument as to why we should allow a cross-appeal where you're cross-appealing from what an appellant has done to reach the interests of a third party who's not the appellant.
As I mentioned, Your Honor, he was party from day one, filed two motions, or one motion to dismiss, two cross motions for summary judgment. He was along for the ride this entire case. We brought the action against the marital community, and we believe the marital community is liable on this case. The dismissal order and judgment are contained in the same, and we've cross-appealed only the aspect of the court's judgment dismissing Mr. Rohr, which again is contained in the same order and the same judgment. So for those reasons, I don't think there's any surprise or prejudice to Mr. Rohr. He testified at trial. He was in this from A to Z. So again, we believe we complied with the rules as far as filing a cross-appeal on the judgment itself that was dismissing Mr. Rohr.
I'm going to ask you another question. It's kind of related. The trial court came carefully looked at all this and ultimately decided not to award you fees despite ARS 12341.
Yes, Your Honor.
And you've not chosen to appeal that decision, but now you're asking for fees on appeal. And I'm not saying that that's a bar in any way, but it does seem somewhat incongruous. So explain to me why you think you don't seem to have a lot of issue with the trial court's decision below, but now you're asking us to kind of...
We obviously don't agree with the trial court's decline to award attorney's fees, but at the same time, we didn't believe that it was or evaluate it as completely unreasonable. I think Judge Warner went through the factors. I think the reasons that he set forth in the minute entry support his decision not to award attorney's fees.
We don't take issue with that.
We don't take issue with that. No, Your Honor. I would argue that at this stage in the arguments that you heard this morning, and particularly Judge Morris, I think you have identified a lot of the arguments and a lot of the statements made just don't appear in the record. To say that, Ms. Rohr wanted to, was afraid because she didn't want to meet on the street corner, that's not in the record. So we feel that this appeal was something that was designed to protract the litigation rather than, either pay the judgment or entertain good faith negotiations and settlement. So we feel that fees are awarded because we don't believe there was a truly good faith basis to appeal the breach of contract. Damages, perhaps less so, but certainly not the breach of contract. I think it's very clear that there was a contract. It's very clear from the communications that she got a better offer after the fact and just, reneged on it, anticipatorily repudiated, and she took it outside of eBay. Mr. Bibian never clicked on Buy It Now. He never did anything within the eBay process, completely circumvented it. The only thing he did with eBay is use their email system. But she was the one that took it outside of eBay. He sent the money by wire. He used PayPal, and then $30,000, and then sent $110,000 or so, 140, whatever it was, to by wire, and used an attorney to draft the contract of sale. Rather than using the eBay rules of contract, they did their own thing with an attorney in New York and drafted their own contract of sale. So again, yes, Your Honor.
So did you make an offer to settle this case after the civil judgment was granted?
Were there settlement discussions? Not really, Your Honor.
Okay.
Not really. We did enter in, early on, and then after there was actually an offer of.
There was something in the record that after summary judgment, as the contract had been granted, that you guys made a settlement offer.
There were two formal Rule 68 offers of judgment that were exchanged. They were not accepted. I believe, if memory serves correct, this is almost a year ago. There was some telephone discussions with counsel, but they really didn't improve on the offers of judgment. So,
can you be clear for me on that one point?
Yes.
You said there were two Rule 68 offers of judgment.
Yes.
Were they exchanged, or were they from one side to the other?
Each side submitted one Rule 68 offer of judgment prior to trial.
Thank you. In other words, it wasn't an offer and then a subsequent offer. It was one person sent an offer, the other person sent an offer.
That's correct, Your Honor. We also attended the mandatory settlement conference, and unfortunately were unable to settle at that point.
And can you recall what the amount of the offers were?
Yes, Your Honor. $60,000 to Mr. Rohr and $60,000 to Mrs. Rohr. Neither party accepted.
Okay.
So, the numbers speak for themselves. So again, we submit that fees and costs in this case, especially since the trial court did not award any fees, and we worked really hard to get to our judgment. My client incurred $54,000 in fees to get through trial. So once we had completed the trial, we get to this point, and we've briefed all the issues, the court can evaluate for itself whether there was, some colorable, appealable issues on the contract and damages. I've spoken about contract at length. Damages, again, it was really unrefuted. And the court gave the benefit.
Yes.
Thank you, Your Honor.
Thank you.
Thank you, counsel.
Mr. Zimmerman?
I think you said I had 2 minutes.
Yeah.
You asked me why Mr. Lynch did not testify about value, and he said in the record, because valuation theory and science, you can only rely on actual transactions. He said that you have to view the actual stone. That's the transcript. You can only look at actual data, comes from actual transactions, not advertised prices. That's in the transcript. I think the case boils down to this, Your Honor. We don't think there was a contract. We think that the contract didn't exist because my client felt very threatened and very concerned, and she exercised her discretion to not sell to this individual. It seems like the court thinks that the buy it now is an actual commitment that she couldn't take away based upon the communication that took place. We disagree. The briefs are pretty solid on why we disagree. We think she was scared and she said so.
Is there and I think I asked this earlier, I'm not sure you answered. Is there a case, any jurisdiction, where a court has found a buy it now doesn't create a contract?
Right. We looked really hard at eBay transactions, and I think what's kind of compelling.
Any similar online, maybe not even a buy it now, but some kind of.
We couldn't find anything, because what eBay says, and I have a quote, I think from the eBay rules, that eBay says this. I think it's helpful. I can find it quickly. I put them.
I'll let you answer, but
eBay says we're not in the contract business. We're a platform. The contract terms are between the parties, and they say this. If I can find it real quickly, because I did mark it because I thought it would come up. Let me look real quickly at. Oh, I've got the wrong. No, it's in this. Our second brief. But let me talk about.
Answer please find that in the record if you can. But
yes,
your time is up.
Okay, so you don't want me to respond? I wanted to respond on
please, but
just on the eBay
yes.
question. Okay, just give me a moment. Okay. The user agreement clarifies that eBay provides guidance through its service related to transactions to be used solely for informational purposes, and eBay members may decide to follow them or not. This is Exhibit 2 in the transcript of page 101. As such, user agreements cannot be said to contain all essential terms and conditions to create a contract between the parties. And that's the site in the record. It's on page 11 of our reply brief.
Thank you, counsel. We appreciate your argument today. We will take this matter under advisement and issue a decision in due course. We're staying in recess while the next case comes up.
Thank you, Your Honor.